I think we can go ahead and get started, everybody. We got a good crowd, and Tara and I will continue to let people in as they come on the line. I want to welcome everybody today. I hope y'all are prepared for the winter storm that may or may not happen this weekend. We're excited to have Marisa from the Public Health Law Center. Even though they are currently today, their offices are closed because of the events in Minneapolis, and I'll let her talk about that a little bit later. She graciously agreed to come on board with us today. So really appreciate it. I'm going to turn the meeting over to Tara. She's going to give us an update from Beth, who cannot make the meeting.
Yeah, thanks, Barbara. Good morning, everyone. Thanks for joining us. Hopefully you're warm wherever you are, and if our weather gets, touchy this weekend, hopefully you stay safe. Like Barbara said, Beth isn't able to join us as we thought, but she did send a written update to share, so I'm just going to read that. And then hopefully we will schedule a more formal legislative update in the future. So just keep your eyes out for that. But this is what she had to share. The vape registry bill passed out of the House and returns to the Senate with amendments. Representative Landing out of Charleston attempted to strengthen the bill and said many times how this bill does nothing to protect children. Second point is the heated tobacco bill is awaiting a hearing in Senate Finance. ACSCAN strongly opposes this bill because it changes the definition of the product and it will be taxed less than combustible products. The FDA defines heated products the same as combustibles. And that specifically is referring, if you guys don't know, to the IQOS products, IQOS. They're popular in Europe, and a few states have approved them here. So you can read more about those products if you're interested. And then a third and final point is that funding for tobacco prevention and control remains a priority. DPH will likely not receive any additional federal funds for 2026. This has the potential of limiting tobacco prevention and control work around the state. ACSCAN is asking for $5 million in addition to what the state already allocated from the revenue of the tobacco tax. A portion of the new $5 million will hopefully come from the Juul settlement dollars, which have yet to be allocated to tobacco prevention and control. So those are the 3 points Beth sent. Y'all can, feel free to reach out to her if you have any more questions about those. But like I said, hopefully we'll schedule a formal legislative update or outlook for the 2026 session in the future. So again, thanks for joining us. As always, our meeting is recorded, and we'll put the recording on our website within the next week or so. We're excited to have Marisa Katz from Public Health Law Center here today. So I will pass it over to her and let her introduce herself and get the presentation started.
Wonderful. Thank you so much, Tara and Barbara, and good morning, everybody. I will go ahead and share my screen. Hopefully y'all can see. Okay, great. All right, so as Barbara said, my name is Marisa Katz. I'm a senior staff attorney at the Public Health Law Center. Thank you so much for having me join your roundtable discussion today. So the e-cigarette registry bill introduced last year, and now as of a few moments ago with Beth's update, sounds like it did pass the House and is going back to the Senate. But I believe it had been introduced back in March, is what we refer to as, quote unquote, the typical e-cigarette registry bill. So for today's discussion, I will go over what these typical registry bills are, including a refresher on the FDA's pre-market tobacco product application process, which is a central component to the majority of state registry laws. And then I'll briefly cover some of the main provisions of a typical registry law, and then just kind of quickly go over those registry bills that don't align with the typical registry law, and what they entail, how they're different, just to give you a broader understanding of the range of these laws. And then from there, I'll address the public health implications of these laws, and then wrap up with some of the Public Health Law Center's resources on this topic, including our interactive map, which tracks where registry laws have been enacted in states across the country. So very briefly, for those who are unfamiliar with my organization, the Public Health Law Center is a nonprofit located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota. Pictured here in a nice wintry moment, which is exactly what the campus looks like today. I said earlier with Barbara and Tara, we're experiencing our coldest day so far of this year's winter season at a balmy negative 20 degrees. We're pretty much indoors today, but our work centers on commercial tobacco control, healthy eating and active living, climate justice, and public health infrastructure programs, which include attorneys, policy analysts, and support staff, all working together to improve public health through the power of law. We believe that everyone deserves to be healthy, and that includes centering health equity in all of our work. This is done with mindfulness of several factors that influence public health, including housing, education, the environment, and a variety of other social determinants. Meaning we never want to offer policy solutions that would cause someone to lose their job or their housing and then subsequently impact their health. We provide free legal technical assistance to communities, public health advocates, and other partners throughout the United States. We also publish on important issues pertaining to each of our program areas and offer trainings and webinars. We do not, however, provide client representation, including the giving of legal advice, nor do we lobby elected officials. If you would like legal technical assistance for any area of commercial tobacco policy, including registry bills, you should absolutely feel free to reach out to us at any time. So this slide, as of since Beth's update, is pretty much out of date, but I'll just kind of briefly highlight that in your state, you still have not officially passed a registry bill into law. It's not without trying. Several attempts have been made to establish a registry law in South Carolina since 2023. Senate Bill 287 is the most recent legislation, and that's what had passed the Senate with bipartisan support back in March of last year. And then it sounds like it did just pass the House this week. As you know, existing law does already require tobacco and e-cigarette retailers to notify the State Department of Revenue of their sales through a business tax application. But that, of course, is distinct from S287, which reflects those typical e-cigarette registry or directory laws that have already passed in several states. Which leads us to what are these laws anyway? So let's start with a quick refresher on the FDA's pre-market tobacco product application process, or PMTA, since the typical registry law does relate to or incorporate the FDA's PMTA authorization process, and of course is therefore central to understanding how these bills or laws are intended to operate. So as you know, the FDA is tasked with authorizing tobacco products for sale, including e-cigarette products. A manufacturer is required to submit their products to the FDA for pre-market review to obtain authorization for their products to be lawfully introduced into interstate commerce. The FDA, if it accepts a product application for review, will then undergo an extensive analysis, or is supposed to, of the product, and then weigh certain factors like the risks posed by the tobacco product versus the benefits to public health, and the impact that placing the product on the market will have on cessation efforts, the potential uptake or initiation of tobacco product use, and other measures. After going through this analysis, the FDA decides to either then issue a marketing granted order, or MGO, that will officially authorize the product for legal sale in the US, or it will issue a marketing denial order, or MDO, that denies authorization for legal sale, or the FDA may issue a denial order but stay enforcement of that order itself or a court may do so if the manufacturer files a lawsuit challenging that decision or otherwise appeals that decision. So as of today, there are 39 products in which the FDA has issued a marketing granted order, meaning only 39 e-cigarette products have been federally authorized for legal sale in the United States. The FDA publishes a list of the products it has authorized, a screenshot of which is on this slide. It's also published a list of products that received marketing denial orders. However, it's not an exhaustive list. So we don't know for sure the universe of products with which denial orders have been issued to manufacturers. Importantly, the FDA does not publish a list of products in which applications are pending. And that's the period in which they continue to be under review by the FDA. So as a result, there's no official channel from the FDA or other federal governmental entity to verify a product's application status other than that list of products that have those marketing granted orders. So what are the main provisions of a typical registry law and how are they supposed to work? So on this slide, this is actually a screenshot and link to Virginia's registry bill, which passed into law in 2024. Virginia is one of the 12 states that now have what we refer to, as I said earlier, a typical registry law, which reflects what is an industry-driven piece of legislation and shares with these other states similar policy provisions. So the typical registry law establishes these product registries, or as you've heard, we sometimes say directories, the terms are used interchangeably, that are aimed at regulating the retail sale of e-cigarettes, and in some of these states, they include other nicotine or alternative nicotine products within the state. So the typical law will allow for e-cigarette products to be sold in states if the manufacturer has a marketing granted order. Products will also be allowed, so that's going to be those 39 products. Products will also be allowed for sale in the state if they were in the U.S. market as of August 8th, 2016, and in which PMTA applications were submitted to the FDA by September 9th of 2020, and in which the application remains under FDA review. And it's that last under review provision that has the effect of allowing products with pending FDA authorization status to be sold in states if the manufacturer submits a certification of pending status. So in effect, this means several tens of thousands of products would be eligible for listing on state registries and therefore allowed to be sold in that state. Products that wouldn't be able to meet this criteria are ones with marketing denial orders, of course, as well as the thousands upon thousands of products manufactured overseas, primarily in China, but in other countries as well. And these foreign manufacturers, for the most part, have not even bothered to submit PMTA applications, nor do they have any intent to do so. So, and that's really what explains the rationale behind these laws, which first came about a few years ago in response to the FDA's huge backlog of PMTA applications under review, combined with the FDA's less than robust enforcement against those vape companies that have ignored the PMTA process, again, largely foreign manufacturers, but that nevertheless, as you know, have products on market shelves. So in other words, registry laws were never intended to protect public health, but instead are market share protection laws created by Big Tobacco to remove market competition by essentially just getting a state's stamp of approval to sell their products while taking off market all those products with which they compete with for sales. So the typical bill also has provisions surrounding revenue collection. So usually an initial then annual fee is charged to the manufacturer to register their product and is directed toward covering costs associated with maintaining the registry. The types of fees vary in the states. For example, Alabama's law only charges fees per manufacturer, whereas other states will assess the fee per product, which means that the amount of fees collected can vary greatly. These laws also usually require regular retailer compliance checks to make sure only those products listed on a registry are being sold. These laws also have provisions assessing fines or other civil penalties against manufacturers and retailers for products being sold that are not listed on the registry. And these amounts vary, but the public health consensus is that the amount collected will fall well short of what it costs to actually maintain and enforce these laws. The more products added to a registry, the harder it is to monitor which products are legal for sale, making enforcement very challenging. Some laws also require a retail license to be suspended or revoked in instances of continued noncompliance. And some states have provisions that require seizure and destruction of products not on a state registry and so forth. So for those states with laws that are atypical, I'm just going to briefly highlight those and how they're different. As I mentioned, the typical bill is not really an effective form of tobacco control policy since it was created by Big Tobacco to eliminate competition and ensure their products are sold in state markets. Within those typical bills, though, there are some differences, and I'll just briefly highlight Florida's law, in which its registry lists products that are deemed to be attractive to underage persons and therefore cannot be sold in the state. So it's basically an inverse of the typical registry, and it's also just limited to single-use or disposable vape products. In California, the state doesn't have a registry law per se, but instead the state attorney general is required to create and maintain what's known as an unflavored tobacco list, which lists only those unflavored products that are legal for sale in the state. This is, of course, the most public health protective version of a registry law, since California already has a universal flavored product sales ban, which we know is a proven tobacco control measure to protect against youth initiation and use of these products. In Maryland, there's no law in place currently, but in the last 2 years, there were registry bills that died in committee, but it's worth mentioning because some of the bill's provisions differed from the typical bill. One provision would have required manufacturers to annually certify a list of information, including brand details, product specifications, marketing and advertising plans, proof of a marketing granted order or pending PMTA application, product imaging and packaging details, plus a $75,000 deposit into an escrow account before products could be included in the directory. And in Wyoming, there was a bill which also died in committee, but is probably the most atypical version of a registry bill in that it did not tie products to be listed on a registry to any marketing granted order or pending PMTA application status. It instead would have required manufacturers to obtain a license from the Department of Revenue. The manufacturer would have been required to demonstrate compliance with the Federal PACT Act, and if foreign manufactured, would have to pass inspection with U.S. Customs. The bill also included an annual licensing fee of $1,000, and non-resident manufacturers would have been required to post a $25,000 surety bond. So very different provisions in that context. So there's a lot to digest with these registry laws, but there are key takeaways, all of which have implications for public health. First, the way the typical bill is written, these laws simply allow for way too many products without marketing granted orders to be in the market. A more public health protective approach might be for a registry to limit only those products that have received marketing granted orders from the FDA. By allowing products with pending authorization, states are allowing up to tens of thousands of products to be placed on market shelves. In Oklahoma, I believe there's between 12 and 14,000 products on their registry, and they're just buried and are really struggling mightily with enforcing that. Second, we know what proven tobacco control policy looks like, and it's not registry laws. Strong, comprehensive retail licensing laws, whether at the state or local level, are best protective of public health because of high license fees, meaningful penalties like suspension or license suspension or revocation, other regulations surrounding zoning and density or licensing caps, and prohibitions on coupons or other price promotions, just to name a few examples. Also, as we know, one of the biggest threats to public health is the universe of flavored e-cigarette products in the market. State or local laws that restrict or prohibit flavored products, including menthol, are one of the most effective ways to prevent youth initiation into product use. With the exception of California, registry laws do nothing to get flavored products off market shelves, and in fact have the opposite effect by allowing them to be listed on state registries so long as their PMTA application remains under review. And finally, as more of these bills are passed into law, we're starting to see that they really do fall short when it comes to revenue generated for states. The longer the product registry list, the harder it is to maintain and enforce, which will mean delayed and lower revenue streams. The typical registry bill assesses fees and fines that are well below what a state needs to actually enforce a registry and to do it effectively. If you remember only one thing from my presentation today, I know it's Friday, it's this: registry laws exist solely for the benefit of big tobacco. Nothing more, nothing less. They were written by the industry specifically to drive out market competition and are not a good use of already scarce state resources. Unless and until these laws start to mirror what we know as strong and comprehensive tobacco retail licensing laws, including flavored product sales restrictions or prohibitions, they are just not going to do much at all by way of protecting public health. To that end, the Public Health Law Center has several resources on this topic that can assist public health advocates who are, as you are, faced currently with pending legislation in your state. We have these bills tracked as they're introduced and passed into law through an interactive map on our website. As you can see, the states are color-coded, indicating where bills have passed into law, which are in red, and where bills have been introduced, which are in gold. And then there are a number of small states in blue, indicating versions of registries that can be considered more public health protective. When you click on a particular state, you'll see a link to the various bills that were introduced. And if passed into law, there'll be a link connecting you to that law. I'll mention as well, there are registry laws currently subject to litigation in a handful of states. Iowa is one of them, as you can see on this slide. So if you click on that state, you'll see a note indicating the law is currently not being enforced while litigation is pending, along with a link to the relevant court order. Your neighbor, North Carolina, is also facing litigation over their registry law. We hosted a webinar very recently on this topic in November. It's particularly useful because it features a panel of experts who have been tracking these laws as in states that have already implemented and enforced these laws. So they're able and in a position to highlight the challenges seen so far, particularly with maintenance and enforcement of registry laws. The webinar also features an overview of retail scanner data collected by and analyzed by the CDC's, initially by the CDC's Office on Smoking and Health before it was eliminated last year, and then picked up by the CDC Foundation. And what the data highlights are how e-cigarette product sales have changed in a handful of states that were the first to pass these laws. So this is great, really important information, especially for a state like South Carolina, where registry bills have not yet passed into law and could be used these slides could be used as evidence proving these laws are not public health protective, despite their appearance of being so. So definitely check this out if and when you have the time. We also have a handful of slightly older webinars, as well as a blog post on registry laws. The links on the slide will direct you to those resources, which provide additional background on registry laws and what they mean for public health. I will send these slides to Tara after today so that she can distribute them to you all if you're interested. And then finally, before I field any questions from you all on registry bills, I just want to take a brief moment to let you know that the Public Health Law Center is actually closed today. I was supposed to have rescheduled this talk with you all, and it will be the only work task that I do today. Because Public Health Law Center has joined countless organizations, faith leaders, labor unions, and other businesses across Minnesota in marking today's State Day of Truth and Freedom. As I mentioned at the beginning, our office is located in St. Paul, where alongside our twin city of Minneapolis, where I'm currently located, and other cities and towns across our state, the cruel and unlawful occupation by federal immigration and enforcement officers continues to create widespread chaos, fear, violence, and uncertainty in our state. This is true for those of us who are native-born U.S. citizens. It's true for naturalized citizens. legal resident aliens, asylum seekers, and yes, undocumented people too, who are also human beings deserving of dignity, regardless of one's views on this country's immigration policies. ICE's terrorizing attacks against the Twin Cities and across our state is offensive on its face and very harmful to public health and safety. Today's statewide Day of Truth and Freedom is a nonviolent moral action and reflection. This means that for today, those of us in Minnesota are not going to work, we're not going to school, we're not shopping or dining out. This is instead an act of community conscience and collective action as Minnesotans stand in peaceful solidarity with each other and our community. ICE's actions, of course, as you know, are not confined to Minnesota, but are most definitely concentrated here, as you've seen in the news. This is an issue that affects all of us as Americans, and so I encourage you to stand with us and with our neighbors. If you are interested and able, there are opportunities to support communities during ICE operations, even if you're located far away, as you are in South Carolina. Thanks for hearing me out on this. Living in Minnesota right now is living in crisis, and I would be remiss not to make a few comments about today's protest. So thanks again for inviting me today. Let's return to registry bills, and I'm happy to try to answer any questions you may have.
Thank you, Marissa, for that. We appreciate it. Does anybody have any questions for Marissa?
It is a hot topic.
I have a question, Marissa, and you may have mentioned it. I'm sorry, my son's home and he walked in during part of the presentation, so I had to answer a question for him. The California and I think it was Maryland bills that are like a public health focused bill, is that what that was? Are they working like with y'all at Public Health Law Center or public health agencies in their state to create those bills?
Yeah, that's a great question. We have not worked with Maryland. We have just, and again, Maryland doesn't have a law in place yet. These were just two bills that had died in committee, but they tended to have provisions in them that I kind of briefly glossed over that could arguably, you know, if you're going to put lipstick on a pig, right, this would be a way with which to do it. And so I think the reason why we would code it blue as sort of slightly more public health protective on our interactive map is that if you're in a state where this, you know, you have pending legislation like South Carolina's, and you want to look to that as at least, hey, maybe there's some extra provisions in here where it can be just ever so slightly better and more public health protective. California's is not really a registry bill as we know and understand them, but it is in the sense that it does provide a directory or unflavored tobacco list. But the thing with California is that the state already has a flavored product sales prohibition in the state, including menthol. So the list is only going to contain unflavored products. It does allow for products that are unflavored with pending PMTA application status. But again, it has to be unflavored. So it is probably the most public health protective version of a directory, just because the state already has a comprehensive flavor ban. And so we know flavors are what gets kids hooked on these products. And so if you ban flavors, you're going to be banning the vast majority of products that would otherwise be on a state registry.
Right. Interesting. Okay. Thank you.
We're also available. So if you are working with any organization on the ground or you yourselves are looking at this and want us to take a look at the current legislation to provide comments, how it could be made better. Again, we don't endorse these. We don't believe that they are not, in fact, a proven public health measure and form of tobacco controls. So we don't endorse them. If you're stuck with them anyway, there are ways to make them better. So feel free to reach out to us for free legal technical assistance and we can review your legislation and if there's a way to possibly push through some amendments or kill it, which would be ideal. That would be, we are here for you.
Thank you so much. Well, if there are no more questions, we're going to let Marissa go. And Marissa, we stand with you and we'll be thinking of you.
Thank you so much. It's good to see you all today. Hope your storm passes you and misses you completely, but in any event, stay warm and take care. Thank you all.
Same to you. Thank you, Marisa.
Bye-bye.
Bye.
All right, everybody. We hope you got some useful information from Marissa. Does anybody have anything that they want to update us on? Any efforts, any work being done that they'd like the group to know about? Any help needed? Or is everybody just anxious to winter-proof their homes?
Be
Yeah,
your answer.
yeah, definitely the case.
Well, everybody stay safe this weekend and good luck. Maybe we'll be at work on Monday or maybe we'll get a snow day, who knows? But anyway, stay safe and we will see you next month.
Great.
Bye, everyone.